Judge, may it please the court. My name is Kiani Alapa, and along with my co-counsel, Mr. Maxwell Copper, we represent collectively the Rabbit River Tribe appellees in this case. Opposing counsel attempts to misdirect this court as to what the issues are. But what this case is really about is the tribe's ability to govern over its own lands and to protect its people from the very real threats that Mr. Manny Duwag represents. A tribe's ability to do this is dependent on the existence of jurisdictional powers. So what it boils down to is just one issue, one question for this court, and that is whether a tribe has civil jurisdiction over a non-member for an incident that has occurred entirely on tribal lands. The district court has answered yes to this question, and we ask this court to affirm that ruling.
Counselor, before we get to the merits of the argument, same question to you. Why does this court have jurisdiction?
Your Honor, this court has very limited jurisdiction. They have jurisdiction to decide on tribal jurisdiction alone. Any of the underlying issues already resolved by tribal courts must be given complete deference. And Your Honor, before I continue, I'd like to give this court a brief...
I'm sorry, Counselor, where do you get that standard review of deference? My understanding is that these are questions of law, and so therefore de novo review is appropriate. So where do you get a standard review that would incorporate deference?
Your Honor, that is from the Supreme Court's decision in Iowa Mutual, and I will quote, "Unless a federal court determines that the tribal court lacked jurisdiction, proper deference to the tribal court system precludes relitigation of issues raised by the underlying claims and resolved in the tribal courts."
What you're suggesting is the district court determined federal court has jurisdiction, but we're not going to go into whatever the tribe decided. So basically, what you're saying, it's not for the federal court, as long as there's jurisdiction to hear this appeal, but we should give due deference to whatever grounds the tribal courts interpreted this, as long as it's reasonable within jurisdictional bounds. Am I correct?
Yes, Your Honor. So, Your Honor, for a brief overview of the points that co-counsel and myself will be covering. First, to address opposing counsel's alleged ICRA violations, I will again address the limited scope of federal review in questions of tribal jurisdiction. Next, to address opposing counsel's jurisdictional challenges, my co-counsel and I will address this in two parts. First, I will discuss Montana versus the United States as a presumption-shifting analysis. In this case, the Rabbit River Tribe enjoys presumption of jurisdiction, and opposing counsel has done nothing to overcome that burden. If this court disagrees with that...
Isn't it the other way around? I mean, did Montana create a presumption against tribal jurisdiction?
Yes, when there is an intervening factor, Your Honor. And if this court believes that there was a shift of presumption and that there is a presumption of no jurisdiction, Mr. Copper will demonstrate that under one, if not both the Montana exceptions, the Rabbit River Tribe still has jurisdiction. So, Your Honor, first to continue with the limited scope of federal review in this case, I'd like to move specifically to the Indian Civil Rights Act in Santa Clara Pueblo versus Martinez. In that case, they directly addressed this Indian Civil Rights Act and the congressional intent of that act. Now, Congress had a debate on the issues raised by opposing counsel, and they expressly omitted a federal right of action in that case and kept the remedy to only a habeas corpus. Now, this was a balance between two competing interests: the fundamental protection of an individual Indian's rights and tribal self-determination. And they found that the balance between the two was habeas corpus.
But Counselor, appellant made a very compelling argument that there's an important difference there with Santa Clara. In Santa Clara, you had a tribal member who was suing her tribe. So because she had a political relationship with her tribe, she had an opportunity to participate in that tribal's governance. Whereas here, the appellant is a non-member, and so therefore does not have that same political relationship. So that's an important distinction. Can you please deal with her analysis there?
Well, Your Honor, according to the language of the Indian Civil Rights Act, it says all persons have these protections. It says all persons do not have a federal right of action, a federal private right of action. It did not make the distinction between a member Indian, a non-member Indian, or even a non-Indian. So based on the plain reading of that statute, you cannot bring a federal right of action. And opposing counsel concedes to this issue, and they ask this court to apply an implicit habeas corpus. Well, for four reasons, this is not possible. First, they cite no cases that allow for a court to grant an implicit habeas corpus petition hearing. Second, they have not exhausted all their remedies in the tribal courts. According to the record, the first time any Indian Civil Rights Act violations were asserted was in the district court, the court below this. Never in the tribal court. They had not exhausted their remedies.
But that's a federal issue. That's a federal court issue.
No, Your Honor, according to Salam versus Warren Creek Corrections in the Ninth Circuit, in that case, it was an actual habeas corpus petition. And because the defendant in that case did not raise the issues in tribal court, they had not...
But this is not a habeas petition, as I stated. Nobody is under nobody's custody. The tribe does not have custody of this gentleman, at least right now.
Well, if your court would agree that this is not a habeas corpus petition, then opposing counsels based on ICRA must not be allowed to be addressed in this court.
If you agree, or if I'm in agreement with what I stated, that this is not a habeas petition because he's not under custody, federal law, there will be no federal jurisdiction at this point.
At this point, but after already...
If he gets grabbed and he's put into federal custody,
no, Your Honor.
I mean, into tribal custody, then the habeas corpus would apply.
Yes, Your Honor, and that moves to my third point, because habeas corpus is a remedy of last resort. There still remains a question, the question before this court, and that is whether a tribe has civil jurisdiction over a non-member for an incident that has occurred on the tribe's land. Until that question is answered, this is not the last resort.
You mentioned it's a civil incident. This man of the walk has drugs, firearms, 25 grand, which is with the weapon, with the drugs. That's, to me, it's not civil. That's a, I know the feds are after him, and they don't want to investigate. Isn't that really a federal crime or a state crime?
No, Your Honor, it's either a civil or criminal crime, according to...
You can't have a civil crime.
Oh, excuse me, Your Honor.
Civil offense, so civil...
Yeah. Yes, Your Honor. But based on self-determination, based on the tribe being its own sovereign, much like a state, they have the option to exercise their civil powers or their criminal powers.
So if the tribe grabs a horse and paints stripes, then the tribe is creating a zebra. Just don't create a zebra by painting stripes on a horse. And it seems to me that this is what the tribe is doing, painting stripes on a horse to create a zebra, and it's really, it's a crime no matter what.
Well, Your Honor, and this goes back to giving full deference to the tribal courts, because that issue directly goes to the Indian Civil Rights Act, and the process that opposing counsel argues should be afforded to a criminal proceeding.
So I'm sorry, Counselor, are you saying that if the tribe is essentially trying to assert authority over a crime through its civil authority, where U.S. Supreme Court has said it does not have authority over non-member Indians or under Oliphant, that we should just allow that? We should just defer to the tribe? Is that your assertion?
No, Your Honor. And this brings me to the next point, and I'll address Montana versus the United States and the jurisdiction over non-members. Oliphant was a criminal case, and the tribe does have criminal jurisdiction over Mr. Manitowoc. The question here is their civil jurisdictional powers. Now, Montana versus United States, opposing counsel focuses on the third holding. There's actually 3 holdings to that case, and they ignore the first 2. It states, the Court of Appeals held that the tribe may prohibit non-members from hunting or fishing on land belonging to the tribe or held by the United States in trust for the tribe. And with this holding, we can readily agree. The second holding was very similar. But the court then goes into a lengthy analysis on how the tribe lost control of that land, and how, because of that, the presumption shifted to one of no jurisdiction. Now, that is an intervening factor, the loss of tribal land. There are other intervening factors.
Isn't there technically a loss of tribal land here? The casino is a corporation, operates that land. This is not a tribe or a member. This is a corporation operating that land. And the parking would appear to me it's part of the casino.
Your Honor, according to page 1 of the record, it is the Rabbit River tribe who owns the casino, and that is the only fact we have in this case. Your Honor, moving to the presumption of jurisdiction, again, there are other intervening factors that shift the presumption from one of jurisdiction to no jurisdiction. In Nevada versus Hicks, they identify a state interest, a compelling state interest that shifts that presumption. They also identify a federal question. None of those intervening factors are in this case.
I thought that the presumption was just existing, that tribes don't